Now, what if the behavior you've been tolerating at work isn't just uncomfortable, but illegal? Every day, millions of women across the United States quietly ask themselves the same question: is this harassment at work? Important clarification: most workplace harassment cases are civil cases, not criminal cases. If you've ever felt uneasy because of a comment, a message, a look, or a demand at your workplace, this video is for you. Before we begin, subscribe to this channel for clear, accurate explanations of U.S. workplace and constitutional law, so you can protect your rights with confidence. Today, we'll break down exactly what the law says, what counts as harassment, what your rights are, and what steps you can take using real-world hypothetical examples, clearly, calmly, and legally. Workplace harassment is not defined by how uncomfortable you feel alone. It is defined by law. Under Title VII of the Civil Rights Act of 1964, workplace harassment is illegal when it is based on a protected characteristic, including sex, gender, pregnancy, sexual orientation, gender identity. For women in the workplace, this protection is especially significant. Harassment becomes illegal when it is severe or pervasive, and it creates a hostile, intimidating, or abusive work environment, or it affects employment decisions such as promotions, pay, or job security. What counts as sexual harassment? Sexual harassment under U.S. law falls into two main categories. 1. Quid pro quo harassment. Quid pro quo means this for that. Hypothetical scenario. A supervisor tells an employee, "If you go out with me, I'll make sure you get that promotion." This is illegal even if it happens only once the employee refuses. No physical contact occurs. The offer itself violates federal law. This happens when unwelcome conduct becomes severe or pervasive. Hypothetical scenario. A woman in an office experiences repeated sexual jokes, comments about her body, unwanted messages late at night, coworkers dismissing her complaints. Even if no one touches her, this can still be illegal if it interferes with her ability to work. Is this harassment at work? How to know? Ask yourself these legal questions. Was the behavior unwelcome? Was it based on sex or gender? Was it severe or repeated? Did it affect your work environment? If the answer is yes to these questions, the law may be on your side. Importantly, you do not have to say "stop" perfectly. You do not need witnesses. You do not need physical contact, what the law says. Title VII. Explain. Title VII of the Civil Rights Act of 1964 is the primary federal law protecting workers from harassment. It applies to private employers with 15 or more employees, federal, state, and local government employers, employment agencies, and labor unions. Title VII makes it illegal to harass employees because of sex retaliate against employees who complain, ignore known harassment, employer responsibility and liability. Employers are not allowed to look the other way. An employer can be legally responsible when a supervisor harasses an employee. Management knew or should have known. No reasonable steps were taken to stop it. Hypothetical scenario. A woman reports harassment to HR. HR does nothing. The behavior continues. Under U.S. law, the company itself may be liable. What is the EEOC? The Equal Employment Opportunity Commission, EEOC, is the federal agency that enforces workplace discrimination laws. The EECC investigates complaints, mediates disputes, allows employees to sue in federal court. You generally must file a complaint with the EECC before suing your employer. How to file an EEOC complaint, step by step. Document everything: dates, messages, witnesses. File a charge. usually within 180 or 300 days. EEOC investigation, right to sue letter. This process is designed to protect your rights, not punish you for speaking up. State workplace laws, very important. Many U.S. states offer stronger protections than federal law. Some states cover smaller employers, allow longer filing deadlines, provide higher compensation. Examples include California, New York, New Jersey, Illinois. State law can expand your rights, not reduce them. Can I sue my employer? Yes, but only under certain conditions. You may be able to sue if you filed an EEOC charge, you received a right to sue notice, the harassment meets legal standards. Courts consider severity, frequency, employer response. Evidence, retaliation is strictly illegal. Examples: firing after complaint, demotion, reduced hours, hostile treatment. Even if the harassment claim fails, retaliation alone can win your case. What are your rights at work? You have the right to a harassment-free workplace report, misconduct without fear. Seek investigation, request reasonable protection, legal remedies if harmed. You do not have to quit to be protected. What you should do if harassment occurs. Keep records. Review company policy report internally. If safe, contact the EEOC, consult an employment attorney. Knowledge is protection. Workplace harassment is not about being sensitive. It's about your legal rights. If this video helped you understand your rights, like this video, subscribe for more U.S. legal education. Share this with someone who may need it. The law exists to protect you, but only if you know it.